Alex here with part 60 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will quickly glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. I also like to take a additional step every 5th video and let my viewers know that if you are not getting every single update on the My Docket series, it's probably because you haven't clicked on the bell notification button. If you are just a subscriber, YouTube will only let you know of certain publications to the channel, not all of them. It's based on their algorithm as to which ones they will send to you, at least in your email. And if you click on the bell notification button, then they will let you know about everything. We left off in part 59 with my motion to delegate parental duties, and in this video we are going into my ex's opposition. So she does decide that she wants to fight this document. I can't say that I was very surprised. I had at this point filed 5 times. 3 of them she settled and 2 of them she fought, and I figured it was about a 50-50 shot that she would want to fight this one too. So she does decide that she wants to resist the delegation of parental duties. I am not sure what she put in her opposition. I guess we're going to actually have to go ahead at this point and take a look at what my ex has filed. Here we have the opposition to motion for delegation of parental duties. First paragraph identifies my ex and her attorney, and also indicates that she opposes the motion that I filed. Usually they will put the date as to when I filed that motion. It's just sometimes you'll have documents that are filed that have the same title over and over again, and it helps to have that date. The courts can figure it out on their own usually, but it's just something that I see a lot of attorneys do. This particular attorney, or at least maybe just in this particular example, she hasn't done that. But one thing I want to point out for my viewers. Let's see what the factual background is here. She cites an email that she received from me giving her a day and a Sunday to contact my ex, requesting that she agree that she'll make all decisions in medical care and then I'll make all decisions in education. Without waiting for a reply from her email, I filed a motion. I guess what she's insinuating here is that I'm supposed to wait for a reply. In this case, after entry, and by the way, that's inane, because then they could just wait for weeks on end. I suppose it's more reasonable to wait a certain number of days, but I guess if her attorney really wanted me to wait a little bit longer, she could have replied to that first email and said, hey, I need more time to look at this. You know, there's a way to go about approaching something like this tiny issue. And anyway, it doesn't really matter because, I mean, I guess it would matter if she wanted to agree. Like, for example, if she didn't want to fight something, I guess it would matter because it would have wasted her time, maybe potentially stressed her out that I filed a motion. But in this particular case, she doesn't agree. She's filing an opposition. So it's not even really relevant. Like, who cares if, you know, I would have given her 5 days versus 10 days versus 2 days. She doesn't agree. She's opposing what I'm trying to do anyway. In this case, after the entry of the custody order, I have filed 6. Okay, so she's playing this angle. She's playing the I filed too many papers angle. So she's bringing up the 6 motions that I filed. This is a very common attorney tactic. They don't really care about the merits of the motions. They just care about the mere number of filings. And this does actually work with a lot of judges. That's why they do it. After the February hearing, I continue to file motions whenever possible. She's endeavored to work with me to address my concerns. That's not true. She's entered into stipulations with me. She has half the time. The current motion was filed without me allowing her any meaningful time for a response. Okay, what are they talking about? The rules of civil procedure give them 10 days to respond. So she's trying to insinuate that there's some unspoken rule that I need to comply with. There's something extra that I'm supposed to do. I also continue to attach a police report to my various motions regarding a medical incident. Okay, under the Nevada revised statutes indicate that the mental health of the parents is relevant to the best interest factors. So if this is a police report regarding a mental health issue, and the Nevada revised statutes indicate that there is, what do they call it, a best interest factor where mental health is relevant, then what I'm attaching to these motions is relevant. There's also something else called the absolute litigation privilege, which, as far as I know, it forbids suing somebody for putting something in a court document. But as far as I know, it would forbid me from being punished for, bringing up certain evidence. There's other things that they can use to punish me, like they call them attorney fee sanctions for filing something without a reasonable basis. But that doesn't really have anything to do with what kind of evidence is included in the document or what kind of assertions are made. It's more so that you are bringing something to court that has no reason to be brought to court in the first place. I guess she's trying to say here that I'm trying to denigrate her by attaching the police report, which isn't true, but it's the best thing that they can do on opposition. In my motion, I'm requesting a modification of joint legal custody. Okay, so according to this lawyer, I was right. I should have just titled it motion to modify legal custody because that's what it is. I'm trying to modify legal custody such that one of us be responsible for medical and one of us be responsible for education. In 2.5 years, I have not attended a single... Of course, you can point out that a parent hasn't attended a medical appointment when the other parent is trying to block them from attending medical appointments. I've talked about this sort of underhanded tactic where they will deprive you of your rights, and then when you finally do get in front of the court, they'll point the finger at you and say, hey, look, he hasn't exercised any of his rights because we haven't allowed him to. But this is just more of the same. Next assertion here is that I have failed to co-parent with my ex by enrolling him in preschooling without consulting her. What? I have begun to develop a pattern of being unable to remain in one residence. As of the filing of this motion, I've moved. Okay, so I don't know about that. I guess moving around a lot when you have a kid in school could cause stability issues. The judge doesn't really care about this. It doesn't come up. I can't remember anything being thrown in my face about moving around a bunch of times, especially given the fact that we had just separated and I was trying to, stabilize my life. But it involved changing jobs a bunch of times, going to going to UNR off and on. And of course, that sometimes involves moving. It's not like I was in my 30s at the time. I think I was 24, 25. The other thing that I wanted to mention is the preschool thing. That's odd to me. She doesn't attach an exhibit. Maybe there's something down there that I can look into so I can see what she's talking about, but I don't recall that being an issue. In addition, she's endeavored to provide educational opportunities for him since birth under her care. Oh, so she's basically stating that she shouldn't be deprived of educational authority because she does all this other educational stuff with him. Argument. Joint legal custody presumes sharing of decision-making. The law encourages parents to share the rights and responsibilities. Legal custody addresses the responsibility parents have to make major decisions. That's true. Joint legal custody requires cooperation and communication. That's also true. I don't know why she's bringing that up, though, because in that same case, Rivero, they state that they can split that up. So it's like she's saying something is true that's not really relevant. Legal custody involves having basic legal responsibilities, blah, blah, blah. Joint legal custody requires that parents cooperate and communicate. That's true. And I actually do use this against her later on. Towards the end of the custody dispute, this line that my ex's attorney is making, joint legal custody requires that parents be able to communicate, that line I take and use against her to deprive her of legal custody. But at this point in time, this early in the case, I'm not thinking that's really an option. Joint legal custodians are allowed to have equal access to information. I'm not trying to deprive her of information only, so that's irrelevant. Scrolling down. The basis of the conflicts is one doctor's visit. Okay, she's trying to pinpoint one specific conflict, and she's trying to argue that because of that one specific conflict, I'm unreasonable. But the problem is that this isn't one specific conflict. This is a number of conflicts over the course of 3 different motions that have been filed in this case. So she's just doing her job as an attorney. She's trying to distract, or I don't want to say deceive the judge. In a way, she kind of is. It's kind of like bringing up a piece of a truth without the whole truth to make her client not look as bad. Okay, so while I do not seek primary custody, I'm attempting to preclude her from sharing in the educational decisions while abdicating my duty. Abdicating. Okay, so she understands. This lawyer is acting. She's playing stupid. The lawyer is playing dumb. She's acting like she doesn't know what I'm trying to do, and she's acting like I am trying to give up one of my obligations, abdicate, like give it up because I don't want it or I'm neglectful or whatever, and I'm trying to take one from my ex. But really, I've stated clearly in my motion that what I'm trying to do is have half or joint legal custody rights in reality, not just on paper. And I kind of gone over this a few times, but right now the situation is that I have joint legal custody in everything, but that's just on paper. In reality, I don't, because she finds ways to deprive me of those portions of the legal custody that I have on paper. So what I'm trying to do is find some way to have at least some kind of participation in something, and even if that means giving up, at least on paper, half of the rights that I would have on paper. Because I got to the point where I was like, what's the point of having all this stuff on paper if none of it's real? And the closest that I can get to really having joint legal custody is the proposal that I put forth in my motion. The entire premise of joint legal custody is for the child to have the benefit of both parents' knowledge, expertise, wisdom. Okay, this is also an irrelevant statement, and it's also unsupported by authority. So she's making one of these general overarching principles of fairness statements that is irrelevant because in that same case, Rivero, the Supreme Court states specifically in that case that joint legal custodians don't have to have the equal rights in both areas. They can split these up. So my motion to divide the medical educational responsibilities deprives him of input from both parents. There's no input from both parents. There's input from one, because that one parent is depriving the other parent of their custodial rights using all kinds of shenanigans. So it's not me that's depriving our son of the input from both parents as to legal custody issues. It's his mom. The only difference is I'm trying to rectify the situation through the court system, and she's creating all these problems outside of the boundaries of the court system through the actions that she's taking. Attorney fees. Again, I think this is the third request, possibly the fourth request that my ex's attorney has made for attorney fees. She goes through the same nonsense, trying to characterize me as a harassing party because I'm filing too many papers. She's not going into the actual substance of the papers themselves. She's just saying I'm filing too many papers. Now, she's also saying that I didn't give her an opportunity to confer. That's not even in the law, so I don't know why she's saying that at all. Okay, so there is specific authority, specific statutes that control how to get these awards. And she's bringing up things that aren't relevant. What's relevant is discussed in my video, attorney fees and costs. And I also talk about how to defeat these requests in the video, defend against attorney fees. Last thing I want to mention is a recent change to a Nevada law that actually makes it a lot easier for these lawyers to get attorney fees out of the non-represented party. And that's in the video, attorney fee equalizers. Take a look at that video as well. It's actually disappointing to see the legislature pass that law, but they did pass it. Luckily, it didn't take effect in my case, so I didn't have to deal with it. So anyway, she's asking for attorney fees. I'm not going to spend a lot of time talking about this because of all those 3 videos that I already put together. And I also want to state right now that she's going to get this request denied. Conclusion. So based on the foregoing, my ex is requesting that my motion be denied and that she get attorney fees and costs. Verification. This is what I always suspected it was supposed to be called. The verification. So now I know. I mean, assuming this attorney is correct. The affidavit that I attach to the bottom of every one of my motions is supposed to be called the verification. Anyway, same thing. It's she's stating under oath that everything asserted in this motion, every fact asserted in this motion, is under penalty of perjury. Here's the affirmation. It's one of those self-help papers. Here is the certificate of mailing indicating that my ex mailed this opposition to motion to my address at the time, of course. We have a motion opposition notice, just like the one that I filled out. And based on the check marks that my ex's attorney has marked, she does not have to pay a filing fee. Index of exhibits. So we got an email and an affidavit. I think here we've got 2 documents that are fresh that I can look over. Exhibit 1. Okay, so this is my email to the lawyer. Ideal, and I wish it could be so, but de facto, my ex continues to marginalize my involvement. The first dental appointment, she attempted to escalate an altercation. It's inappropriate and will cause friction between healthcare providers. Okay, so I talked about this before too. It really alienates the healthcare providers for them to see the conflict. To see us as 2 parents who look like crazy people alienates them from us, makes them want to discontinue service, and makes it less likely that they're going to be as helpful as they possibly could be to our son. Stepping back will result in cooperation on paper. What is she talking about, stepping back? So there must be a thread here. And complete takeover by my ex de facto. Yeah, de facto, as I mentioned to my viewers, de jure means on paper, or officially de facto means in reality, off paper, what's actually going on. I'll hold action until Monday unless my ex agrees to stipulate. Much appreciated. I'm going to go through these. I hope it's not too much. What does my ex's attorney state? She says she'll forward my email to my ex. She doesn't believe that the remedy that I suggest will be the one that my ex chooses to implement. Joint legal custody means both parents have a say in all aspects of it. Okay, again, lawyers do this. So she's making a general statement. Joint legal custody generally means both parents have a say in all aspects of a child's upbringing. Okay, we know that, but Rivero states that you don't have to do that. So the same case that states that, in the next sentence they state it doesn't mean you both have to do the same thing at the same time. Sometimes I feel like they try to talk down to you or condescend you, but really they're just trying to trick you. Either that or she's completely ignorant about how Rivera works. One of the two. Next statement or next email is that hope things are going well. No drama, just facts. We attended our first medical appointment. Went to sit near him. She requested I sit far across the room. Had no contact. During the appointment, she insisted a third person was present. It's not appropriate for me to involve dental and medical offices in our disputes. It's good for him to continue contact with the offices, and making a scene would cause issues for the... Okay, so same thing that I reiterated on reply. Able to obtain medical appointments, keep up to date on the status of his medical care. Therefore, I believe in this case it is appropriate to delegate parental duties. Weller discussed the authority. Oh, so even Weller said that. I remember this now. I even brought this up in my Docket video that went over this. So Judge Weller actually brought up everything that I've been talking about in the Rivero case and in my motion, which is ironic because he denies it. I want to mention to my viewers, please watch the video. The judge does not remember you, because the judge will make statements at a hearing, completely forget them, and then deny your request. So yes, it's annoying for me to see that this was actually something that he contemplated, yet when he enters the order denying, it's like, it doesn't even matter. Okay, I believe it's appropriate for us to maintain control over medical care and for myself to maintain control over educational care. The court can't force us to cooperate, and this would look like the best solution. Exhibit 2. We got an affidavit here from Robert Burr. This was one of her designees. Okay, at the dental... Oh, so he was the one that she brought with him. At the dental appointment, I tried to sit next to her. She requested that I don't. She made no threats to make a scene. Did not attempt to speak to his son. Chose to sit at the far end of the room? Alright. I looked through an automobile magazine and showed no interest. Wait, what? Oh, the child showed no interest in my presence. Okay, so this is actually, I think, damaging to their case. It says here, had the child wished to interact with his father, he would have been able to do so. So what they're trying to insinuate is that the child, or our son, didn't want to interact with me. Courts I don't know about that. Little kids, I mean, maybe a teenager. And that's because there's sometimes drama between teenagers and parents. But generally, little children love their parents. Let's see here. She did not insist that I be present. Mutual friend. Attendance at the appointment. Previous on healthcare appointments. Okay, so he's talking about being in attendance at the ones that I wasn't at. Weird. Okay, I didn't know that. I raised no objections to his presence. Of course, we're not going to cause a scene in public. When in the checkup room, the dental assistant attempted to have Army sit in the dental chair. That required Army to be seated closer to me. Army immediately responded by saying, I don't like daddy. Ooh, that's damaging to their case too. I don't remember that. And refused to be brought closer to me. Ouch! And that's not an ouch for me. That's when I see something like that in a document like this, that makes me very, very suspicious of the person asserting it. So I did not attempt to speak with him or reassure him. It says here, I was visibly embarrassed that my son was reacting to me that way. And the last assertion is that I made no discernible effort to participate in the dental appointment other than just standing and watching. The lawyer should have known better than to prepare this. So the lawyer should have known not to include certain things in here because these look bad on her client. That makes me question the lawyer. For the most part, throughout the years, I've always thought that the lawyer was actually the one that made the most sense between the lawyer and my ex. But this makes me question that. Because if a judge, I don't know about things back then. I mean, nowadays, if a judge sees stuff like this, they immediately assume that the mother, or in this case, the mother, is doing something to coach the child. Going on to the next one, notice of change of address. We have here, okay, we've gone over these a bunch of times in the past. I have a video dedicated to notice of change of address. If you want to take a look at that video, I would highly recommend it because it's one of those documents that somebody might look at and think is, how to describe it, like a piece of paper that's a formality. That's the word I want to use. This is not just a formality. This is a document that controls how you're being served in your court case. And if you move and don't let the court know that you've moved and documents get set to your old address, they don't care that you're not there anymore. That counts as you having been served even though you don't live there anymore and even though you never got the piece of paper. So please watch my video, Notice of Change of Address. This is not just a formality. Filing these one-page pieces of paper are crucial. Going into the aftermath, I didn't file, well actually I did file a notice of change of address. It's a free filing, so I incurred $0 in costs. My ex's attorney filed an opposition to my motion, so it was also a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. In this case, my ex's attorney would have probably put more than just preparation of that opposition into what it took to actually put it together. There's also an amount of time that involves communicating with my ex, probably conferring over the phone, maybe in her office, strategizing as to what they were going to do on opposition. And of course, gathering the affidavit from Robbie was also, that takes time. I think it's safe for me to put this at 2 hours. I do suspect it was probably more, probably 3. But erring on the conservative end, as I've done throughout the series, let's go ahead and put it at 2 hours. The notice of change of address is negligible considering we're putting 2 hours on the opposition. So at a rate of $250 an hour, that's going to come to $500 in attorney fees. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.